Well, welcome everybody to the National Conference of Bar Presidents 21st Century Lawyer webinar. We have so much to cover today, and I'm thrilled that you've taken time out of your day to come join us. You'll see on the slides that there are our Twitter handles, and I want to encourage people. This is hopefully this seminar will give you a lot of things to tweet about and to discuss. And it'd be nice to be able to share both the thoughts of Jane and Bill and the things you see on the screen with those around us who couldn't be here today. So please feel free to use the Twitter handles. I'll tell you briefly, for those of you who don't belong to the National Conference of Bar Presidents, that we are the organization that helps train and grow bar leaders and bars nationally. Through concepts of growing leadership and innovation and collaboration. Some 53 states, minority bars, metro bars are all members of the National Conference of Bar Presidents. And if you're not a member, I encourage you to join. One of those benefits is being able to be part of monthly webinars like this, the 21st Century Lawyer, as well as attending our mid-year and our annual conferences. So, all right, today we're going to tackle what this legal landscape looks like across the country. And there's been so much change. There was this discussion that happened with Bob Ambrogi in his articles where he was saying, is it just an echo chamber, or is change really happening? And I've been a big proponent that change really is happening. Today, I'm going to show you, we're going to show you, but not only is change happening, it's happening by the week, it's happening by the month, it's happening quickly. It feels at times and on days like there's a tsunami of change going on. And if you're not part of that, if you're not seeing what's going on and you're a bar leader, then today is your day really to get up to speed with the things that are happening. Understand that the difference between running a bar by looking in your rearview mirror versus running a bar that is building a bridge to the future is huge in this day and age, and it could actually mean the existence of your bar or the decline of your bar in the very near future. So I'm glad that you're here, and with me are really, I think, two of the biggest opinion leaders and two of the biggest voices in the legal landscape, Jane Reardon and Bill Henderson. And I already apologized to them off camera because I could go on and talk about these two at length, but I want to spend our time really focusing on our topic. So I'll give a very brief introduction. Bill Henderson is a professor of law at the Maurer School of Law in Indiana. He is well known for so many things. He's a regular author, writes columns continuously. He is frequently a speaker in national conferences. He's a legal rebel. We invited him to the National Conference of Bar Presidents to speak. He's a thought leader and an opinion leader, and importantly for today, he was also the writer of the Legal Landscapes report that California is now using. Also joining us is Jane Reardon, who's the executive director of the Illinois Supreme Court Commission on Professionalism. She's a past ABA Standing Committee on Professionalism chair. She has been instrumental in creating a national conference that goes every year, the Future Is Now conference. And Jane, that is May 16 of this year, if I'm right, in Chicago. Everyone should be there. Everyone should sign up. It's an amazing conference. She is also a regular speaker nationally, writer, tweets continually, and I'm always out there liking and pushing out things she says. Anyway, both of you, welcome. I'm very glad to have you here. Really, without further ado, let me just jump right into this. And Jane, I'm going to turn this over to you. I think that one of the common themes that we're seeing in these changes that are going on across the country can come down to like two possibilities or two impetus. One is Rule 5.4, and the other one is the Janus decision, now the Fleck decision. And we talked about Janus and Fleck last month during our webinar, and so we're really going to focus on what changes are now occurring and on 5.4. But Jane, let me turn this over to you just to talk about maybe that underpinning of 5.4 and why this seems to be the nexus for so many of the changes.
Sure, thanks Patrick, glad to be here. The reason that 5.4 is the decision point is that the broader view is, are our ethical rules standing in the way of delivering legal services Are they causing the access to justice? Are they inhibiting lawyers from being able to better deliver legal services? And so a number of ethical rules touch on that, but really and truly, Rule 5.4, which if you have a screen, you should just take a look at A, B. They say lawyers may not split fees or share fees with non-lawyers, and a lawyer can't form a partnership with a non-lawyer in order to practice law. Okay, and we've all taken that as just part of our ethical obligation. But I researched this, and looking at the genesis of this rule, going all the way back, it's been in the ethical rules since the first codification in 1928. But the basis for it were two issues that were going on at the time. There was a concern that the banks were taking up too much legal business. In other words, protectionism is the basis for this rule. And the other one was that personal injury lawyers were passing around money to ambulance chasers. So solicitation is the other one. And this, but this concept has been codified in every iteration of the rules, all the way through to the model rule 5.4, the model rules of 1983. But what was interesting is in 1983, yet another restriction was added on. If you can see, Rule 5.4D made it even more restrictive in terms of the structures that lawyers can practice law in. It says that, and there is a slide on this, it added a proscription against non-lawyer ownership, management, or anything that would control the independent judgment of the lawyer. But what was weird about it is there's no history for it. The comments are exceedingly thin, and they say that this rule expresses traditional limitations on sharing fees and traditional limitations on permitting third parties to direct or regulate the professional judgment of lawyers. So the point is, I think, for this webinar and for the profession generally, is what are those traditional limitations? Why are they there? And what harm are they providing to lawyers and to members of the public? And I think we really need to keep that in mind.
Well, and that is a great segue into this next kind of discussion, putting some more flesh on the bones. Bill, let me turn to you. There has been this big shift. I think everyone is watching California, right, with the things that have happened with their bar. And they came to you and said, will you write a landscape report for us? And in May or July of last year, you wrote and published that report. Can you tell us some about this California task force? And it's a task force on access through innovation of legal services. I don't know what that turns into. ATLs, is that what people are calling it?
I don't know. Thank you, Patrick. I'm absolutely delighted to be here. What's on your screen right now is the first paragraph from the executive summary of the California Legal Market Landscape Report, and you can find it on the CalBar website. If you can't find it, navigate there. You can just find it at Legal Evolution. We've got a link to it. Anyway, I was asked. I was the precursor to the Task Force for Access to Justice. As a matter of fact, I was at the meeting where they actually approved the creation of that task force. And before the trustees voted to do that, they wanted to have a descriptive overview of the market, and that's what I was commissioned to do. It was really just basically a descriptive report. And the way and one of the points that from that is that the market, insofar as it's regulated, is regulated by the ethics rules. I mean, you think of all the other economic activities where there's commissions that regulate that activity, but it's just the ethics rules that shape the current part of the market. And the takeaway that I used, or the framing device I used, was from sociology, where the sociologists have studied the legal profession. They've broken it into two markets. One market serves people, the other market serves organizational clients. The original landscape report for that was 1975, where roughly half people serve half lawyers served people, half served organizations. They replicated that study through the American Bar Foundation at the ABA, and are affiliated with the ABA. And their takeaway was basically the organizational market is growing very much faster than the people law segment, and the people law segment was actually beginning to slow down and show signs of stress. And drawing upon that research, I used the best available data to show, can kind of provide an update of what's going on in the people law market. And basically, we see the actual people law market shrinking. We see lawyers struggling to earn a living there. We see data that shows that lawyers spend about 30% of the time looking for work and about 40% of the time doing work, legal work, and not always collecting on it. So that's in the people law market. But here you can see at the other end of the spectrum, large corporations complaining about the cost of legal services. And this is really driven by the fact that they just can't keep up with the complexity of operating in a regulated, interconnected, globalized world. And to stay in compliance, to do it in a bespoke way is very, very stressing. And so if we look back at this market, we can see that although we have a prohibition against non-lawyers engaged in the practice of law, and the people law segment, we see tremendous inroads by companies like LegalZoom and Rocket Lawyer and many, many companies coming in here, figuring out ways to tap into an inefficient latent market. And over on this side here, we see all sorts of alternative legal service providers getting around 5.4. So the future has already arrived here because there's so much opportunity to tap into this improvement in the market. And the way to solve what I call a lagging legal productivity problem here, the solution is invariably multidisciplinary solutions. And so my charge to look at 5.4 is really to invite allied professionals to come in and help us solve these things on an equal playing field, as opposed to having the lawyers supervising people with disciplines they're not familiar with.
And Bill, I love this idea of allied professionals. We in law so often divide it between lawyers and non-lawyers, which just is such a dissonant word, I think, for so many. So allied professionals, I think we all ought to highlight that, underscore it, hashtag it, live it. I think it's a great descriptor, and I appreciate you for bringing that out.
Thank you.
So Jane, we know that one of the ways to change ethics rules, one of the ways that landscape is being changed is through bar action, through state bars. But organizations are taking the bull by the horns and making big strides forward. Can you kind of give us an understanding of what organizations are taking the lead and what kind of actions they're taking?
Yeah, sure. As everyone here knows, the ethical rules are established by state Supreme Courts. They tend to take our association or their individual commissions or councils in each state. So adoption of change really is variant, right? Here in Illinois, though, I really must highlight the Attorney Registration and Disciplinary Commission that put out a very lengthy report well over a year ago on client-lawyer matching services, and has put it out for comment and has received comment from across the country. The basic premise of the report or conclusion is that by barring under our ethical rules lawyers from participating in for-profit matching services, we could be perpetuating the lack of access to the legal marketplace. And we, of course, as lawyers have an obligation. Our whole purpose of the profession is to provide legal services. And so the ARDC has taken a position and made a couple of proposals that the Supreme Court actually allow lawyers to participate in these matching services, whether they're for-profit or not-for-profit. Right now, of course, you can do it if it's not-for-profit or bar-related. But the proposal is that lawyers be allowed to do it, and or that the Supreme Court actually regulate, very soft regulation of those for-profit matching services. Register in our state, pay a registration fee, and put in place some protections for clients, such as malpractice insurance, no charging unreasonable fees under Rule 1.5, submit to the jurisdiction of the court, because arguably Supreme Courts don't regulate technology companies, right? They only regulate the legal profession. So this is a very forward-looking proposal that's taken front and center, and I think the Illinois Supreme Court is, or at least the commission is poised to make some recommendations based on the feedback from that report fairly soon. On the national scale, I'm really excited to tell the bar leaders, if they don't already know, about a very ambitious effort being undertaken by APRL, and there's a slide on this. It's the Association of Professional Responsibility Lawyers, if you don't know. They've established a Future of Lawyering committee that is going to operate very similarly to the report and recommendations of the advertising rules that this organization came out with in 2015 and 2016. That those recommendations actually spurred the ABA to action, and they were adopted and are now being adopted by the state. So the people in April, and this Future of Lawyering Committee is being chaired by a past president, Art Lockman, and Dan Jakobowicz, the upcoming president, have set up 4 subcommittees to look very, very broadly at the issue of referral fees and fee sharing, which is 7.2 essentially, Rule 5.5 issues, Rule 5.4 issues, and firm management. There are members not only of APRL, but other people who are not members of the organization who have a breadth of perspectives to provide. And so we have liaisons from the ABA Center for Professional Responsibility. They've been in contact with the Conference of Chief Justices, which is really important because, of course, the Chief Justices ultimately decide what ethical rule changes will be taking place. They also have liaisons from the Federal Trade Commission, the Legal Marketing Association, and NOBC, which is Bar Council. The idea of this is we're going to have a national look at the issue that pretty much everyone agrees with, that the legal needs of a large swath of American people aren't being met, that non-lawyer or allied professionals are filling those spots, other legal companies who are not subject to the ethical rules, and the ethical rules aren't adequately addressing the realities of today. So at the end of probably 2 years, the hope is a set of recommendations for major change that will accommodate a legal profession that is able to provide legal services to this large group, especially of people law that Bill talks about, and also allow lawyers to make a living, because right now the system isn't working for either the clients or consumers of legal services or a large number of lawyers who are struggling to make a living here.
And Jane, I know that ISLES is also taking some steps. Are you in a place to talk about them as well?
I can just mention very briefly, ISLES is the Institute for the Advancement of the American Legal System, and they are another national organization, thought leaders here, and they are convening a group of people from across the country to look at the issue of entity regulation. And that's coming up, and they're going to start to work on that fairly soon here. And Patrick, you mentioned the Future Law Conference. I do want to mention that this year we have a speaker, Carolyn Elephant, you know her, who has a really provocative talk, and the title is Killing Solos Softly, How Ethics Regulations Threaten Solo and Small Firm Practitioners, in particular, choking them. So she's an outspoken and very and very influential thought leader. So we're grateful to have her speak this year.
Yeah, I'm looking forward to that conference, Jane. And I'll add one more group. The American Academy of Arts and Sciences, which is a huge institution, has also jumped into this access to justice, legal innovation space. And they've formed a committee that really is manned and womaned by the who's who of the country. And they've divided it into a number of subcommittees. One of the subcommittees is looking at innovation in regulation in particular, which is right on point with what we're talking about here. And they're meeting throughout this year and next year. And I'll tell you, the firepower on this committee is something. I'll just give you a sense of who is on this and who is meeting. Margaret Hagan, our incoming or president of the ABA, Judy Martinez, Perry Martinez, Mary McQueen, Dan Rodriguez, James Sandman, John Suh, among others who are part of this Innovation for Regulation committee. And so I think we can expect to have a significant and sizable report with really some amazing recommendations coming out of the Academy. So there's lots going on with organizations that maybe aren't strictly state bars who are pushing things forward. Let me also mention back to some of the state bars that are making changes, and we can advance the slide for a minute, Teresa. Oregon has been working on changing rules, and so we're looking at 5.4 also. And what I have in front of you is the two possible changes. Both were recommendations from their subcommittee going back to their board of governors that talks about for-profit lawyer referral services as a way of chipping away slowly at that prohibition of sharing attorney's fees. So Oregon is taking the corner and they're making that step forward, and we'll see what happens in line with where APRL has been and is heading. I'll also give you an update on what's happening in Washington State. I was the past president there, and I don't speak on behalf of the bar for sure, but I know there's a lot of people that are kind of watching what is going on in the Washington State Bar, and I'll tell you, it's a lot. And if you advance the slide again, there's a practice of law board that is going one direction, and in there they're recommending changing the definition of practice of law as part of our civil rules. So we've talked about our ethic rules changes. We talked about some structural changes via Janus and Fleck. This is a change coming by way of our civil rules to expand the practice of law, which is interesting because the exact opposite thing is happening the other side of the country in Tennessee, where its legislature in House Bill 1411 is saying it is an unauthorized practice of law to do document preparation or self-help websites or consumer interaction in law. So you have these two states juxtaposed, one going forward and one going backward for regulation. Other things going on in Washington, I think, highlight something that I'm going to have Bill talk about in greater detail here in a few minutes, which is this tension between the duty to the public that we as bar leaders have and the duty to our members of our bar. In Washington, we put it right into our mission. Our mission is to serve the public and the members of the bar, right? Well, the problems that occur with that tension can be big or small depending on who your leadership is. In Washington, we used the public side to create the LLT, Limited Licensed Legal Technicians, right, which was a project that has been duplicated in other states across the country, including Utah. We've also created things like access justice programs, including the Moderate Means program, which was a partnership with law schools to help people who had moderate means to get reduced fee lawyer referral service to get legal services. I mean, these are big changes, and I think Washington's always been an innovative state. But there's been a pushback recently with our Board of Governors, and the pushback has been protectionist. It's no, we don't want those things. Instead, we want to take the protection of the members first and the public second. And while that tension always exists in bars, the tension has resulted in some significant changes. For example, the Board of Governors as it exists in a split vote fired our executive director. They recommended turning back 7 years, 8 years of forward-thinking, innovative bylaws. And when they attempted to reverse those bylaws, our Supreme Court stepped in and put a moratorium on changes to the bylaws. The Supreme Court stepped in. Because the bar is looking protectionist, the state legislature has also now stepped in and they passed a bill 96-1 repealing the State Bar Act. In fact, there was an article that came out that I'll share with you. If you can see this in the newspaper article, the headline this week is Washington State Bar Association faces possible extinction because the legislature is revoking essentially our charter, the legislative underpinning of the bar, and handing the entire bar over to the Supreme Court. So these are some significant changes that are going on. At the same time, the Supreme Court has convened a structures work group. And so the Supreme Court is looking at how to restructure our mandatory bar. You may read into that, perhaps dividing the bar to a regulatory bar as well as a voluntary bar. That leads to a lot of questions, and other states have gone that way, say like California. There's now a petition that is going on among the bar members to reinstate our executive director and try to take the bar in yet another direction. We'll see what happens. I will tell you, all this has happened in a very short period of time. It can show you as bar leaders how quickly you can go from an innovative, forward-thinking bar making big changes to advance access to justice for the public versus what happens when you make that huge ideological shift to be more protectionist, look after the members of the practice first. You may have your Supreme Court, your legislature coming after you and making changes they think are best for the public, regardless of what you think are best for your members. So it's going to be interesting to watch. I will just add this, know that your courts are watching, know that your legislature are watching what you do, know that they can intervene depending on how your structure is created to change what you do, and that we as a profession are self-regulated, but that is a privilege and it is not a right. And you have our Supreme Courts and legislatures out there poised to take action where necessary, where we're not doing what's best for the public. Instead, we're self-dealing. So I think Washington is a cautionary tale. But before I turn over to California, which is kind of the segue to see not only what happens when you do go wrong, but what happens when you get it right, I just want to put in a piece about alternative business structures, because this sits in the background of so many of these discussions. Jane, can we talk about that for a minute?
Yeah, I'd be happy to talk about that. It seems like this is the third rail for bar leaders and has been for decades. Alternative business structures, as you can see on the slide, allow, and they use the word non-lawyers, but that's in our ethical rules, but allows those who don't have a JD to own or manage the organization, allows passive investment or allied professionals as well as lawyers to join together and deliver legal services, okay? That none of that is allowed by Model Rule 5.4. But as you probably know, ABSs have been approved in Australia, 2 of the states, New South Wales and Victoria, which contain 80% of the lawyers, and have been operating since the 1990s there. Their legal firms can have allied professionals, they have outside investment, etc. Also, they're prevalent in the UK and in parts of Canada. So proponents of ABSs say that they would be helpful because they would improve the access to justice situation. Okay, we as the United States have been dropping year over year in the World Justice Report. And Julian Hatfield, you mentioned earlier, a leading expert on the problem, says There is no humanly possible amount of legal aid or pro bono services that can satisfy the access to justice problem here in America. She strongly advocates a change in the regulations would address this. The other proponents also say you're going to get better pricing for your clients, right? You're going to improve customer service, one-stop shopping if they want to talk with, how about an accountant at the same time as their lawyer or a social worker or a psychologist. It encourages innovation. That's been proven by research studies that have taken place in England, because here in the US, their partners just want to divvy up the profits at the end of the year. They have no incentive to put money back, to make capital improvements, to invest in technology, et cetera. And the other benefit is to have access to capital. Right now, if you're a partner, you can seek bank loans or partnership buy-ins, but if you permit ABSs, you might open up opportunities like mergers of law firms, franchise options, cooperatives, et cetera. Passive investors might be willing to take more risks, and you need capital to innovate. And the other reason that ABS would be helpful is people would have a piece of the business, flexibility and remuneration. Right now, if you need a technologist, like most lawyers do, you must hire them. They cannot be your partner in the law firm. And there's an argument that's made over and over that, oh, it's all right, you know, they should just lawyers should hire the expertise they need and pay them a salary and maybe a bonus. But, you know, ask those people who are elbowing their way into the partnership ranks whether they would be satisfied being an employee all the time. There is a certain attraction to being a part owner. And so these things would all be allowed, are allowed in the countries that have ABSs right now. By the way, Mark Cohen recently wrote a great piece about what we call accounting firms. The big four professional service firms all have ABSs, are all operating as law firms in Singapore, the UK, and elsewhere. Talk about putting ourselves at a global disadvantage. It's really a situation that I'm hoping all the bar leaders take a very close look at, because we are falling behind day after day, it seems like. Let me address very briefly, if I have time, Patrick, the opposition to ABSs. Over and over again, you see in writing and you hear, well, we don't really know that it would help the access to justice gap. It's going to help anything. We need to see some data on that. Well, that is such a tautological argument, I would say, because we can't collect data because we're not allowed to do it here in this country. And data from the other countries that are doing it actually show that the benefits are accruing there. And the other one that slays me as the executive director of the Commission on Professionalism is that forming an ABS, particularly working side by side with allied professionals, would really undermine the core values of the profession. I think this is incredibly disingenuous. It kind of falls into three buckets. The law is a profession, not a business. Yes, it is a profession and it is a business. I think most lawyers go to law school with the idea that they're going to be able to make a living, right? And so in the annual profits per partner and all of that belies that we're not in altruistic, not-for-profit foundation here. It's a way to make a living. And under the current scheme, lawyers are incentivized, right, to take the cases that are going to get them the most fees, to bill if the file can support greater research, et cetera. Billing by the hour puts us in an incredible conflict So to say that if the profession and not a business is not a reason not to change the structure to allow that. And in terms of diminishing the lawyer's independence, we already have our regulations in place to keep lawyers ethical, to keep them independent. There are situations now, I did many years medical malpractice defense. Insurance companies paid my fees, but they weren't supposed to direct my activities. There are all of those conflicts right now going on within the legal profession. So we take care of it in other ways. We'll be able to do it if there's ABSs too. And in terms of, will weaken client loyalty, this is one that I really, frankly, don't understand. I don't think clients have any idea, for the most part, that lawyers are not allowed to go into business with an allied professional, nor do I think they care, nor do we ask them as a profession. We create these ethical rules out of a sense of paternalistic. We know best what the clients need, but if you ask Responsive Law, which is an organization, and Tom Gordon is part of the APRL benefit, that represents the interests of individuals in the legal system. They've put forward many times that their clients would welcome the opportunity to go to a more holistic approach, to have their legal problems analyzed and solved along with the others that are related. So I think that the opposing viewpoints are mostly protectionistic and really don't stand much scrutiny. I don't know whether ABS will ever be adopted in this country, but I think it's a mistake if they're not seriously considered.
Well, Jane, thank you. I think that kind of underpins some of the discussions that we're having today. And it leads us here. John Lund, I'm going to have you address us just for a minute. So John is the past president of the Utah Bar. And just to share with you how quickly things are moving from the time that we decided we were going to do this webinar through today, Utah has taken some amazing steps forward and are moving at such a quick clip that we hadn't originally planned to talk about Utah at all. And now it's important to give Utah a few moments in the spotlight and share what they're doing. John, are you there? And can you spend about 3 minutes, maybe just giving us an update on what's happening in Utah and the changes that are going on there?
Sure, Patrick, I'm here. Can you hear me?
We can hear you.
Great. Well, it's good to be with you. And this is really an interesting and wonderful opportunity to get the broader perspective. I'll try to be quick about this, but we are being quick about this. We have formed up a joint task force of the Utah courts and the Utah Bar, largely at the bar's request, I would note, to really look at the broader issue that's being discussed today. Myself and Justice Dino Himonos are co-chairing that. We don't really have an official name, but it's kind of become euphemistically called the Bigly Task Force because apparently that's a real word, and one of our justices has started using it in his opinions. And the concept is that we want to, move bigly here, and so that's the concept. We have some great members on this task force. Tom Clark from the National State Courts is on it. Jillian Hatfield is helping us. Margaret Hagan, Lucy Rica. These are all of our sort of national experts and voices that have been so willing to help us out. And there's a statement of purpose online, which I'd be happy to share, but essentially there's two things we're looking at. One is how to relax and loosen the rules for lawyers to permit them to be more innovative, be more flexible in their arrangements, better solicit in ways that are safe and appropriate. That's track A. Track B, which is kind of maybe going to hopefully meet some of the issues that are being raised here. Track B is to create a regulatory sandbox structure here in Utah where, at least for the next couple of years, the court would authorize an independent entity to take, proposals from non-lawyers, to take proposals from a mix of lawyers and non-lawyers, or as you said, allied professionals for some particular legal service that they want to deliver, and do it in a way that would sort of test these types of ABSs or other structures that are in place with a data flow back to find out what results there are, with a focus on what the risks may be associated with that type of an approach, and get back to it. So that's moving quick. We hope to have a report by the end of June for our court, but I can tell you that Justice Simonis has generally softened the ground for us to actually try to implement some of this. Another thing we just did on this past Saturday that I think of as softening the ground is we convened our Supreme Court Advisory Committee on the Rules of Professional Conduct, which is a great committee, but largely steeped in the existing rules, as you might imagine. But Margaret Hagan and Lucy Rika came out and ran a design workshop for them, specifically on 5.4. And our focus was really not so much on what does it do or not do for the lawyers or how they behave, but what do those rules do or not do for the users? And the types of users we're talking about are not necessarily the ultimate consumers, but they might be you know, a national plaintiffs firm that's trying to figure out how to structure itself, or somebody that wants to do Social Security disability consulting across the country. What are the rules doing that either help that person get where they want to go or not? It was a really fascinating morning, and hopefully we got some discussion going. Just by way of example, you know, we got on the subject of landlord tenants and all of this unrepresented parties in eviction proceedings, and you know what to do about how to bring those people some legal services. Well, you know, as the discussion evolved, somebody pointed out that the entry point to that may be long before they're in an eviction court. It may be when they're actually forming the lease arrangement in the first place, or getting some consultation, you know, as the problem evolves. So the question came up, what could a lawyer do in concert with somebody like Zillow or Apartment Finder to help people, give them consultation about the lease they enter in the first place? Now, you know, that's just an idea, but the core theme here is we believe innovation has to be, we have to create the conditions for innovation to be allowed, whether that's lawyer-driven innovation or innovation driven by venture capitalists or whoever it is. It could be innovation, you know, garage, in the back of your garage style innovation, or it could be Walmart wants to innovate and they want to provide some type of legal service through their platform. So that's our real concept of a regulatory sandbox, is we are seeking those innovators. We are wanting to find out, you know, what are the conditions need to be for them to actually come in and innovate, and then can we let them try something is the central concept. Ultimately, and I think this is very consistent with the conversation that we've been having so far, it seems clear that the regulatory environment for legal services needs to move in three critical ways. One is that it needs to be independent. And I know this is hard. I know Elizabeth Reith, who's our general counsel, is on the call. It may mean that bars that currently are the mandatory regulatory entity need to restructure and reimagine themselves so that they can function as an independent regulatory board. That's one. The second, we're talking about things being risk-based. You know, the slide Jane had up about lawyers and their professional independence and their sense of integrity as a profession versus a business. The question we have to ask ourselves about all of that is, well, how is that harming somebody who's an actual consumer of legal services to have that be a concern? And if the rule is really only protecting that element of professionalism, which, you know, doctors and accountants and all manner of people that work in ABSs all day long, you know, they think they're professionals too. So we think that we really need to work towards an independent body. We think that we need to work towards regulations that are risk-based and empirical in their reasoning. And lastly, and this is probably the most ambitious piece and why I'm glad that there's so many people having this conversation, you know, this needs to be national, if not global, in terms of the potential. It's not going to do a lot of good for little old Utah to let Walmart come in and do something innovative in Utah if it can't be scaled to the country as a whole or the company as a whole. So
yes, John, you were so right. I appreciate you taking time to come in and chat with us and share that. Utah, it really is turning into a shining example of what it looks like to take the next step and the process we can go through and the blueprint we need to do. Let me use that to head into Bill. We've had you sitting on the bench way too long. There's some common themes that tie all of these things together, and I can't think of a man in a better place than the guy who wrote the Legal Landscape Report and who teaches and studies this for the base of your expertise. There's some common themes here, and one of this is this duty to the public and the tension that's created and the stories that have come, for example, in California. Help us bring this all together and understand why that's such a critical concept.
So in California, a law was passed that retooled the California bar, took the mandatory bar and split it into a regulatory bar and basically a trade association that advances the interests of the lawyers. And the way that law was put together was there's going to be 7 lawyers but 6 public members, and it really boiled down, in my experience with the trustees, that's the board of trustees. It boils down to a group of people that see a need and an importance to regulate the public interest, which is the statutory language. Now, that statutory language has been around before, but this group of 13 seemed like it really wanted to give it a fresh look, and that's what commissioned the landscape report. But I want to just highlight one issue here and to pick up on what John Lund said regarding there is definitely a trending toward this public interest. And this is the involvement in the state Supreme Courts, because they, in most jurisdictions, there's case law that says they have the inherent authority to regulate the bar. And it's not just the rules of professional responsibility in 5.4 that are the kind of the keys to the kingdom. Actually, I don't believe that those are the keys to the kingdom. They're a piece of the puzzle, but the Bar Association needs to work with the state Supreme Courts, and Jane highlighted this point here because you go into any state court and you're going to see tremendous numbers of self-represented litigants, and these are people that don't put any pocket or any dollars in lawyers' pockets and aren't likely to, because the amount in controversy just can't support lawyers on both sides of the matter. And I just want to bring everybody back to what my friend Jillian Hatfield, who's an economist and lawyer, said in her book Rules for the Flat World. And we are living in that flat world right now. She says the more that people feel like the rules don't care about them, they don't care about the rules. And the public's perception of government and how a government is working interfaces very much with their ability to use the state and the court system to satisfy their needs. And right now, many, many people are shrugging their shoulders and saying, this isn't going to do any good. I can't go to court. I can't afford a lawyer. And this is really eroding at the very core of our democracy. So I'm not giving you a lecture here. As a matter of fact, I'm not a bar president. I just look at the current state of it and just say something needs to be done here. And I know that the California trustees probably are very interested in this issue as well as the Utah Supreme Court. But really, there's a reason why there's a trending toward public interest, because this is affecting the function of our government.
So with that, we've touched on kind of this laundry list of things, right? You said, and you're exactly right, the 5.4 is not the answer, but one of a number. Legislative fixes, regulatory fixes, rules of professional conduct, right? Part of the regulatory fixes, maybe structure changes in bars from mandatory to voluntary, regulatory bars. And all of this revolve around that duty to the public, or what's in the best interest of the public, or access to justice, or whatever you want to call it. And I love this idea of a legal regulatory sandbox. I think that's genius from Utah, and I'm glad to see they're putting it together. Let me turn this over to you both, and Bill, starting with you. We have all these leaders, both bar leaders, opinion leaders, watching you both today. And I'd like them to be able to take away some things today that they can walk back to their bar, back to their boards, back to their Supreme Courts, back to their legislature, right back to the people that are around them, and say, here's what we need to do and here's why we need to do it. I wonder if you can give us some takeaways, give us some things that we can take home with us today.
I would be getting together. The state bar presidents need to get together with the state Supreme Courts and have a conversation regarding how well the system is working for the citizens. And the judges will have a lot of ideas because they're overwhelmed with self-represented litigants, and that's just the tip of the iceberg here. But I think that will focus our attention on this public interest issue. And the world we're headed into is so complex. We're going to need lawyers and we're going to need legal service professionals, but we need to change the rules so that we can actually serve all the people that need us. And so I guess that would be my talk to the state Supreme Court justices, because these two groups have to work together. One working alone can't do it.
Just jumping in on what Bill said, it is so ironic that, and we all know this, the world is becoming more legally complex by the day, and yet we have the increasing numbers of people who are shut out or don't access lawyers or those who are legally trained to help them solve their problems. And ultimately, that's on us as a profession, I would say. I mean, we exist to provide legal services to the public, to make the law work for them. And it's kind of a pact on our house that this access to justice gap continues to widen. The other thing, just to amplify what Bill said, it is really clear that our state Supreme Court justices need the help of the bar. They don't understand these issues. They do understand that there's a lot of pro se litigants in their courtrooms, but it's been a long time since they practiced law. And I don't think they understand, and I know they rely on the bar leaders to keep them informed and to tell them what needs to be done to help them understand the issue and what needs to be done to address these problems, or at least give them some options.
I'm wondering, let me just toss this out there as a maybe a talking point for a moment. Some bar is going to be the first bar. It's going to be the domino, right? The first domino down that's going to be making these changes perhaps in a regulatory sandbox, and maybe they're not exactly the right rules, and maybe the language isn't perfect, and maybe there's some people that want to debate it and talk about it, right? But let's suppose that some rules come out, some changes come out, and we have a place where fee sharing is allowed, where outside money can come in, where low-income people or moderate means people may be able to afford lawyers more effectively. And yet we have this question, if we build it, will they come, right? No state wants to be the first state to do this and just to hear crickets and chirping because the legal environment is still too risky for companies to come in or for lawyers to partner and build joint ventures. I'm just wondering your comments about this. Let's just say we're there and Utah's going to do it, California's going to do it, right? Maybe Florida, who has been having some conversations, maybe they're going to be stepping up. Who knows? But what kind of things can bar leaders do, you think, to do exactly what John Lennon was suggesting, make this regulatory environment warm and friendly so that everyone succeeds and lawyers thrive with these changes?
Well, one thought that comes to mind is we might need more than one or two states. You need a tipping point. I don't think you need half of the states, certainly, but we already have a type of ABS that's allowed in the District of Columbia and there in Washington State with the LLLTs. That's not enough, and I wonder whether it's because people practice across state lines quite a bit and they don't want to get in trouble. So, but if you get a California, Florida, Utah, and one or two others, then there might be enough cross-pollination to have it grow. I also think the states have to probably create a safe haven or something else for others who come in to make sure that there's some sort of reciprocal acknowledgement if one state's ethical rules have changed and the others haven't. So there has to be some I would think, some cross-state discussions about those.
Hey, I want to just put a brief plug in for this diffusion of innovation. Just from the point, Patrick, you asked states going first, and I know there's a chart here, I can't put my finger on it right now, that shows over a period of about 20 to 25 years how legislation on hate crimes propagated through all 50 states here, starting with one jurisdiction that went first here. And I really do think that there's actually some benefit to being the early adopter here, because really, this isn't really about enabling businesses to be successful. This is about improving access to legal services and the functioning of dispute resolution and the commercial interest of enforceable contracts and things like that. And there's just a huge amount of upside here to getting to recalibrating the rules, the regulatory environment for the benefit of of each state. A lot of glory.
I like that word, recalibrate. Recalibrate's a good word, I think.
Yeah.
Well, I thank you both for being here and having this conversation with us. And I'll say that it's a conversation I hope each one of you who are on today has with your governors, with your leadership, with the opinion leaders around you. There really isn't a path forward without talking about these things. And it's going to take all of us, I think, engaging in the conversation to find the best solutions and to share those best solutions and to grow our profession in ways that are healthy for the public and that can be endorsed by our legislatures and by our Supreme Courts and by those who need us the most for access to justice. I'm happy to answer any questions or to provide any questions to Bill and Jane. I'm not seeing any on the screen, although I will note, just to push out, that in Utah, Margaret Hagan is offering a workshop on Friday, April 5th about the Utah project. There's a link that you can go to if you'd like to find out more. I'll also suggest to you that we're going to talk about this topic and we're going to break it out in much in a bigger way in our annual meeting in San Francisco at the National Conference of Bar Presidents, and that is in August 8th, 9th, and 10th. And you're going to hear more about the landscape. And you know what? The landscape's going to continue to change. We're going to have an updated report by the time we get to August, and you'll see just how quickly things are moving. On behalf of the National Conference of Bar Presidents and the 21st Century Lawyer Committee, I thank you for being here. Thank you so much, Jane Reardon and Bill Henderson. You guys are rock stars, and I'm thankful for everything you do in our profession and appreciate you being here very much.
My pleasure.
All right, folks.
Bye-bye. Thank you.
Go make your work. Take care, everyone. Goodbye.
Bye-bye.